Welcome to another episode of Vows and Verdicts. This is episode 2, No More Love and Law. We had to change the name up.
Vows and Verdicts. Yeah.
Sure, if you caught the previous episode, we spoke about it a little bit briefly, but had to make a name change and missed a couple weeks, so we're back. And this topic, I guess we'll be discussing, will be more about the criminal side of our firm, our business.
The verdicts. So when we opened the firm back in 2009 officially, we did more criminal defense, as I've said before. Having been a former prosecutor in Clayton County and in Fulton County, it's what I knew. So we did criminal defense. And so this is the verdicts side of it. Little play on the words to talk about the criminal side, TDE, criminal defense attorneys. So we made a business decision to separate the firm. Instead of having Tessie D, Edwards and Associates, we separated and made two firms, TDE Family Law and Divorce Attorneys and TDE Criminal Defense. And so now we have the two separate firms specializing in criminal defense and specializing in family law. But we tend to talk a little bit more about the family side. So today we're going to talk about the criminal side.
I have no criminal experience.
Well, I've been on the other side of that myself a time or two. Like I said, I've talked about it a lot. I was kind of born and raised in the PJs and had some issues before and after the law degree, I would say.
I've seen some things in my days.
Well, I digress. As a criminal defense attorney, obviously it can't be anything too major. I'm still a licensed attorney. I've never had any major thing that would have caused me to lose my license, but I did take a gun into the courtroom that Charles left in my briefcase. And
what happened was, I forgot that it was in there, and she went into court.
Cobb County.
And as I was cleaning out the car, I was looking for the firearm, and I just assumed that she had taken it out, not out in her briefcase to court.
How would I take it out if I never knew it was in my briefcase?
It was wishful thinking.
So we're leaving court, and because some clients was leaving with us, he didn't want them to see that he had a gun, so he stuck it in my briefcase. We left and went on a trip. I think we went to Disney World, actually, the Universal. We went to Orlando, took the kids for a school break trip, came back, went to court. He rode with me, and I go in, and, hey, you have a firearm, zero tolerance. You're going to jail. As
I'm looking for the gun at the car wash, the phone rings, and it was the sheriff, and she said, "Ooh." And as soon as she said, "Ooh," my heart dropped. And I called every bondsman that I knew and every attorney that I knew and told them what happened. And the rest
made the
is...
news. I was called the pistol packing lawyer.
Mm-hmm.
The pistol pack. I had clients calling me, "Attorney Edwards, you good? You need me?" I'm like, "I just got you out of jail. Sit down somewhere." But anyway, it ended up being dropped, but I did get arrested. Scared. I was in jail. I sat in a cage for like 11 hours.
I was scared.
Yeah.
I was worried.
They told me, don't get out and get rearrested for hitting them. I'm just like, I can't believe this. Honestly, it was more annoying than anything, to be honest. I was very frustrated. And the officers kept saying, "Counselor, you okay?" Don't call me that. I'm sitting in there doing consultations the whole time I'm sitting in jail, answering people about their cases.
And there was another lady that did the same thing that day that got arrested too.
And that was a grandmother coming in to pay her grandson's child support. And you forget that it's in the same like way at the airport. If you take your gun and some zero tolerance, you may get arrested. So anyway, that was
behind us. In the past, we made it. We're still married. I had lots of prayers. Prayer warriors came out and prayed for me. I got lots of calls from friends and family members like, "Ooh, you better not be late to pick her up." I was there 30 minutes early waiting with her coffee.
The prosecutors handled it very gracefully, and it was
scary,
thrown out. But anyway, that's just one of the
in the past.
So on the criminal side, I guess the first thing is what areas do we practice on the criminal side? We literally handle everything from murder to petty theft in the Atlanta metro area. For something more serious, we will travel anywhere in Georgia, like. For a murder case, of course, we'll go all over Georgia, but I'm not going to travel 3 hours for a DUI. It has to be a very serious felony for us to go outside the metro area, but we do handle Fulton, Cobb, Gwinnett, Clayton, DeKalb, like Rockdale, Henry, like metro and just outside the metro area for most cases. And I think the biggest thing that I think a lot of people don't understand about getting arrested for let's just say a felony, because those is the time that it takes to prosecute that. A lot of people don't understand, first of all, there's levels to this. When you call the police and the police come out, your control over the situation has ended at that point. Like 99% of what you can do has ended after you have engaged the police. You call 911, they show up. From that point, the police come out, do an investigation, talk to the witnesses, and then they're going to make a decision about what they're going to do. A lot of times they'll ask you, what do you want to do? You want to have them arrested? You don't want to have them arrested? Are you okay? If they believe that it's they'll ask you your opinion. Some things, of course, they're not going to ask you your opinion. She has a black eye. You broke into the bank and, you stole a car. Some things are not going to ask your opinion, but it's the police officer's choice of whether an arrest will be made. And they can include you in that decision, or they may not include you in that decision. After they have made the decision to make an arrest, you're booked in, fingerprints, mugshots, whatever. People need to understand that the judge has that first snapshot at first appearance of whether or not to go forward with your charges or not. They have a preliminary hearing. That magistrate judge that makes that decision, they have the opportunity then. But once you get arrested from there, it goes to the prosecutor. And after your case has been indicted, the prosecutor is the only person that can dismiss your charges.
What is indicted? Can you explain to them what that means and how long does that take? Because we get that call.
It depends. In Georgia, a felony they have up to, from the time that you're arrested, they have 4 years. In most cases, they have 4 years to bring that indictment.
4 years?
4 years. Some things don't have a time limit, like murder.
Is there anything that you can do to expedite that?
It depends on the county. It depends on the prosecutor. If you know people, and this is where being in Georgia since 2005 license helps, and you know people who know people, and you may be able to call the prosecutor's office and say, hey, I have a client that was arrested on this. Can we expedite it? In reality, though, think about this. Prosecutors are busy, voluminous caseload, crazy caseload. You're asking them, hey, can you pull my client's file and speed this along? Most of them will say, sure, if he's willing to take a plea. They're not going to go in their volumes and boxes of cases to prosecute to hurry up and rush themselves to trial to help you with your client. Like, they have an unlimited amount of cases who are there based on the time of the arrest. Because again, they got 4 years. So you're saying, take my client from the back of the line, put him in the front of the line so we can go to trial. They're not going to do that. 9 times out of 10, they're not. But you may be able to call them and say, hey, I have a client who wants to take a plea. He got arrested 2 months ago, 3 months ago. Sure, because it will resolve the case very quickly for them. But they're not going to take your client and rush them to the front of the line for a benefit to you and a disadvantage to them. That's just not going to happen. But the prosecutor has the ultimate charging authority. They're the ones that decide what you will be charged on or with, and they decide whether or not your charges will be reduced, dismissed, all of that. Now, a judge is largely a referee. The judge will announce, we're going to dismiss the case. This case against you is dismissed. They don't have the authority to do that once you've been indicted. They don't have the authority to dismiss your charges. They make the announcement that the prosecutor has made that decision. And they will be the one that announce it for you sometimes, but they can't dismiss your charges. So when I was a prosecutor and you're talking to people in conversation, they're like, oh, so what do you do? I'm an attorney. What type of attorney? Prosecutor. I'm thinking, okay, you clearly have this wrong. You want my card. You want to get to know me. I am the person that decides whether or not your case is dismissed, reduced, thrown out, make a recommendation that is reasonable, even if it means dismissing the charges. You're going to pay a defense attorney to come ask me to do that without going to trial. And people need to understand that, like, the prosecutors have a lot of authority. So now being on the other side of that, when I'm calling a prosecutor and saying, hey, ADA, blah, 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 this is my client, can you take a look at this? And I'm pitching my client's position to them and trying to get them to see my side. I'm asking them, be reasonable. Look at this. Let's do that. And if not, we can go to trial. But a lot of times you'll get more flies with honey. And knowing those people who have the authority will save your client a lot of time, money, and energy of not having to wait 4 years to be indicted, possibly, and going to a very strenuous trial that could land them in prison. If we can present our case and our argument to the prosecutor, get them to agree to our side, showing them the evidence before we get there, we may be able to resolve something. But people need to understand that the prosecutor, once that case has been indicted by a grand jury or direct indictment, the prosecutor is the only person that can formally dismiss or reduce your charges. The judge doesn't have that authority. So the police officers don't even have that authority anymore. Once they've made the arrest, it goes to the prosecutor, and the prosecutor is the one that will decide if you are indicted. Even at first appearance, a judge can dismiss charges, and a district attorney can direct indict you. Like, the prosecutor has so much more authority than people believe that they do or are aware that they do. And the judge kind of referees. This is when we're going to have this hearing. We have a hearing, and the judge makes a decision. After you make your argument, they referee and decide whose motion is, viable. I grant your motion, I deny your motion. I object, I grant your objection, I deny you. Like, they play more of a referee role. You go to a jury. If it's a jury, I present my side, you present your side. Again, the judge is refereeing objections, exhibits that come in. You're refereeing. When the jury decides guilty or not guilty, if they decide guilty, the judge can sentence. But again, they don't make decisions of innocent or guilt unless you're doing a bench trial versus a jury trial. Bench trial means you're going to have your trial only in front of the bench, meaning just the judge.
So now that it's been indicted, how do those steps look? What happens next? What's the time frame? Because again, these are just some of the questions that I get or that come into the office. Okay, it's been indicted. Now what? I'm innocent. Why can't we just show them the evidence and be done with it?
Well, after the case has been indicted, the next step, the next court date that you're going to have is an arraignment. An arraignment just simply is a court date where you say you're guilty or not guilty. We always say not guilty. I don't care if you got caught with the cookies in your hand on camera. Not guilty. The state has to prove it. And that sounds crazy, but it is not always as black and white as it seems. And we enter a plea of not guilty, and we ask for the discovery in the case. Discovery means police report, witnesses, any evidence they're going to use to try to prove that you're guilty. So that first hearing is arraignment, guilty, not guilty. And then from there, you may have status hearings. You may file, if the attorneys file any kind of motions to suppress, or just different type, Jackson Denham motions, just a different type of motions. I said Denham, Jackson Denham motions. You'll have a motions hearing about the evidence that can and cannot come into the jury trial. If you're going to a jury trial, you'll have a calendar call. Calendar call is where you're letting the judge know, are we going to now take a plea? Are we going to go to trial? Letting the court know what is our position now that we've done arraignment, we've had discovery, we've went through motions. What are we doing now? Are we taking a plea today? Are we scheduling the case for a later plea? Are we going to go to trial? And if we're going to trial, again, is it going to be a bench trial or a jury trial? Giving them a little bit more direction on how we're going to finalize the case towards the end of the case. And then we get set for a trial date if we're having a trial.
But I'm the client. You got the discovery. It shows that I'm innocent. Why are we still in court? Why isn't this done? Why isn't it over?
Well, it's an opinion largely until you prove it. And when you say you got the
evidence,
discovery,
it shows that it wasn't me. It was somebody else in the camera.
I don't think that it's ever that cut and dry.
I mean, it's agreed. But
so when you're saying you have the discovery, if you get the discovery back and I meet with you, go over the discovery with you, and you are presenting arguments to me about why this is not you or why it was self-defense or whatever the defense is. When we go over the discovery, that's when we will come up with what your defenses are. Mm-hmm. And after we have the discovery, a lot of times there are calls to the prosecutor's office, and they do agree, yes, we got the discovery back and you were right, it was this, or you were right, we should reduce this or dismiss this or whatever. And that's when the real negotiations can truly begin if we have been unsuccessful before the discovery in preliminary talks. Now that we have the discovery, a lot of times it is when the prosecutor and the defense attorney have the most meaningful conversations when we get the discovery. And if it's bad news and I'm telling you, well, look at this, we have this, talk to me about this, and we talk about this. And I tell my criminal clients all the time, if I'm not buying it, I can't sell it. If the shit don't make sense to me and you're telling me something just because you're talking doesn't explain what it is, well, what you're saying has to be believable. I have to have evidence to support it. And a lot of times, in most cases, you will not be testifying, client. You will not be testifying. So what other evidence do we have to refute it? I don't have to prove that you're innocent. They have to prove that you're guilty. So a lot of times the evidence that my clients give me is just for me to tear down their evidence. Not that I'm putting on anything, but it gives me the ammunition and the information so that I can tear down and refute what the state is saying. On cross, I love a good cross-examination. When you say I'm arguing and debating, I love a good cross-examination. I love a good closing argument. And it is where I get the opportunity to present what I have learned about why what they're saying is not credible, not true, or there's a different side of it. Example, in a DUI case, people will get arrested for DUI and you're speeding and you're going a 80 and a 65 and the officer pulls you over and they smell beer on your breath. You are going to jail, people. Please don't do any of the field sobriety exercise. That's another conversation for a different day. You're giving them evidence to prove that you're under the influence. And people have this thought, well, if I'm going to pass the intox, you don't have to fail the intox to get arrested for a DUI. So I smell alcohol on your breath, says the officer, and you're going 15, 20 miles over the speed limit. You must be speeding because you're under the influence. You don't do the breathalyzer. Even if you do it, you blow under a 0.08. You're still going to jail. And if I had met you for lunch and I don't speed in reality. You speed a lot. But you don't drink a lot. Because he always says I drive like an old lady. But what I'm saying is, if I speed a lot all the time,
Tended to.
If I meet you for lunch and we literally share a beer and I drink a couple sips of beer and I'm racing back to work and I have beer on my breath, the officer pulls me over, he smells beer on my breath and assumes that I'm speeding because I've been drinking or I'm up because of the level of beer or whatever, and you smell it on my breath. That is the wrong assumption, but a lot of people will get arrested for a DUI for speeding, and the officer smelled alcohol and put one and one together and came up with 97 and you're arrested. Okay, I'm speeding because I always speed. And you smell beer because it's the last thing. I took a swig right before I walked out and you smell it on my breath, but I'm not under the influence. And even if I took the breathalyzer, the officer says, okay, well, you're still under the influence. You drunk too much. And I get arrested. But when I'm having that conversation with the prosecutor, now I can put reason together and oftentimes get it reduced to a reckless driving, because it is still reckless to drive 15 or 20 miles over in a school lane or whatever the other facts may have presented itself. But I'm saying now that the discovery has came back and the prosecutor can see the footage and they can see me and see that, okay, well, she did take the test and she didn't blow, or she took the test and she didn't even blow a 0.1, and she doesn't appear to be having slurred speech or bloodshot eyes or whatever. So this doesn't look like it's a case that I'm going to win on. So let's just give her the speeding ticket and call it a day, because we both agree that my client was speeding. That type of thing. A lot of times you can't do that until you have the discovery. So I'm going to meet you, go over it. Now, on the other hand, you're like, no, I was all of this until that footage comes back. And now that the footage came back and your speech is slurred, you did the field sobriety exercise, you twirling around like a ballerina when you're trying to walk the one line, and all of these different things. Your nystagmus is all over the place. Your eyes are jotted all over the place. There's a lot of evidence to show you are under the influence. And sometimes my clients see that for the first time themselves and they're like, oh.
seen those.
Yes. And
you did the Karate Kid pose in the middle of the
walking
sobriety.
Yeah.
Like, look, I'm not drunk. I can do the Karate Kid pose. He didn't ask you to do that. You're doing too much.
Yeah.
But, a year, I'm still upset because a year and a half later, now you have the evidence. Mm-hmm. And why aren't we done? Why aren't we done? It shows that I was fine. I did all the things. I passed. And a year and a half later, why is this taking so long? But I'm upset.
Well, people need to understand it's the government. The government normally moves slow. We'll just say that. Normally moves slow.
You're inundated with a large number of cases, and you are one of the many.
Yeah, we just had a client that waited a long time on a case. He lost his job. He was falsely arrested because of a bitter wife. Now they're going through a divorce, but he lost his career. And it took years before we got a court date because he was adamant, I'm not taking a plea of any kind, any sort whatsoever. So we had to wait that process. And it was arraignment, motions, calendar call, bump. Because even when you go to trial, and now we're on a trial calendar, they're going to start with the older cases. They're going to start with the people that are in jail. So you're out on bond, and there's 20 cases ahead of you that are waiting to go to trial. So it can be frustrating to a client that doesn't understand why we keep getting continued, because they're going to go in order. And we're in 2026. And so a case that's been waiting for trial since 2025, they're going to go before you. Somebody that's in jail in 2026 waiting for trial, they're going to go before you. So
what is your advice to a person that feels like their attorney isn't doing enough and they're innocent and they contact the courts and the judge?
Please don't do that.
Why?
Please don't do that. One, your emails are landing with the secretary. The judge will never read your email, your mail, any of that. And as soon as you reach out to the court, they contact us and say, talk to your client. Basically, they're doing too much. Tell them this is improper. No one can have communication with the court independently. If I am communicating with the court, I have to CC opposing counsel. So there's no what's called ex parte, meaning by yourself. No ex parte communication without the other party. So you would be CCing the other person, but as long as you're represented by the attorney, you can't have any direct communication with the court, even if you did copy the other party in it. So it's not going anywhere. It's going to make you look unreasonable, just really rogue behavior, and you're going to get the court's attention in a way that you don't want. So go through your attorney. We have literally been fired from a client who was so frustrated. You're not doing enough to get me a court date. Filed a bar complaint. It got dismissed. We have filed for a hearing. We have numerous emails back and forth with the court. We'll get to you when we get to the point that the court started getting rude with you. We heard you, Attorney Edwards. We heard you. We'll get to you when we get to you. Fired us, filed a bar complaint. It was dismissed. Hired another attorney. Still took over a year and a half for your court date. I have no control. The attorneys don't have any control over when the judge sets their calendar for your case to be heard. We can request it, we can follow up, but we don't set the judge's calendar, and we can't make them hear your case before they put it on the calendar. So I understand it can be frustrating. And my goodness, in Fulton County, if you get a case in Fulton County, particularly a DUI in the city of Atlanta, and you don't take a plea or you want a jury trial, when you bind it over, meaning going from municipal court to state court, municipal court doesn't have jury trials. So if you want a jury trial, you got to bind it over to the next higher court, which is state court. They are less than a mile away from each other. And for whatever reason, it literally takes, on average, a year and a half to 2 years for you to get the next court date from City of Atlanta Municipal Court to Fulton County State Court.
A block away.
Wow, it's more than a block away, but it's like I said, about a mile away, and it really takes, on average, about 2 years, and that's crazy. And they're calling us, and they're frustrated. So again, managing your client expectations before we bind it over, I have to tell them, you need to understand, we're going to do a jury trial. For some people, it's a great strategy. It delays the time, but for other people,
it's the worst thing that could happen to them.
They're so irritated that this is hanging over their head. Some people have lost their license, all of that, and you're talking about 2 more years, and I'm talking about that's before you get your first court date, which is arraignment, And then you're waiting on the discovery, and the whole process starts all over again.
And we're all guilty of it. When if you would have just took the Uber, all this could have been avoided.
An Uber is a lot less expensive than a DUI. Bonding out, probation, attorneys, even if you
job security,
go to court and you're found innocent and the case gets dismissed, it could easily be avoided with catching a Uber, having a designated driver. But on some of the other more serious charges, some of the counties are worse than others in Atlanta. DeKalb is another one that takes forever to get a court date. Some of these counties are just really egregious about getting court dates, and there's very little that your attorneys can do. But on the criminal side, I think some of the key things that people really need to understand is what that process is and how long things take, regardless of who your attorney is. People need to understand that, again, what you're arrested for. Another thing is not necessarily what you're going to be indicted on. I think this is what you were talking about, Daryl. If you can be arrested on 2 charges and then people go, oh, they threw the book at me, they got all these trumped up charges. Understand that there are levels to criminal charges, and a lot of time the state is going to kind of stack their deck by adding lesser included charges. For example, if you are arrested for murder, oftentimes you will see that you have murder, you have ag assault, you have aggravated battery, you'll have more charges. You're only going to be found guilty of one if we're talking about one victim, because the state may not be able to prove that you are the reason that the person died, but they can prove that you caused the actions that caused them to die. For example, if I stab you, I'm charged with murder, but they're also going to charge you with ag assault with a deadly weapon, because I could have stabbed you, but that's not why you died. It sounds like who's?
That ain't what killed him.
Yes, that ain't what killed him. You may have died from crazy. You may have had a brain aneurysm at the same time, and they were unrelated, bad set of circumstances, but you died from the brain aneurysm, which had nothing to do with me stabbing you and puncturing a lung. That's not why you died. The autopsy revealed that you had a brain aneurysm, but they're going to still go forward with the stabbing. We had a case where we had a mother that was charged with murder of her child, and she had given her child cough syrup, adult cough syrup. And the little girl was less than 10 years old. Mom didn't know she had some underlying condition that had never been an issue. Mom didn't have pediatric cough syrup, and gave her a little bit of cough syrup. Child went outside, played, so on and so forth. When she laid down for a nap, she didn't wake up. Autopsy revealed that she had this other rare condition. There was no way that the mother could have known that the child had this condition. So the murder was reduced to the underlying charge of criminal child neglect, and that was for giving the child the adult cough syrup. That is a harsh reality, because again, she lost her child, but I want to say the child might have been like 5 or 6, and you gave her adult cough syrup. So you'll have these different charges. You didn't intend to kill her. You did intend to give her adult cough syrup. So they dismissed the murder charge after a long battle, and they went forward with, and she pled guilty to I want to say the charge was a felony child abuse or child endangerment or something along those lines. But that's why you'll have multiple charges. A better example is like stealing a car. If you steal a car, they'll charge you with, let's say, grand theft auto. They're also going to charge you with theft by receiving stolen property, because you're driving down the street in your Trackhawk and the police pull you over because there's a bolo for it. You're in possession of it. I'm going to charge you with stealing this car, and I'm going to charge you with being in possession of the car. Because if I have difficulty proving that you're the person that stole it, I still have you in possession of it. Because just because you're driving the stolen car does not mean you're the person that stole it. I could have stole it and then let you use my stolen car. So they'll generally stack multiple charges to make sure that they can catch you somewhere in the damn web, if that makes sense. Because again, I can't prove that you stole the Trackhawk, but I can prove that you're in possession of it. And because it has a bust out window and you're driving it with a steering wheel, with the screwdriver, if TV serves me right, you're driving it with the screwdriver. So you should have known, a reasonable person should have known that this car was stolen. And I can prove that you were in possession of it, even if I cannot prove you stole it. So you may be arrested and have 3 or 4 different charges, and the prosecutor will add all those charges so that they can hang their hat on the lesser included charges if it gets to that.
So let's do some definitions real quick, because I don't know what the hell a bolo is, and I don't think most people who are watching this know what that is.
Okay, so to back up a little bit, a bolo is be on the lookout. So if they put out a bolo for the stolen car, they're looking for a Trackhawk with, license plate NN 1234, and the officer sees this Trackhawk and they pull you over. They can't prove you stole it, but they can prove that you're in possession of a stolen car. So you get arrested for 4 or 5 different charges, or you get arrested for stealing the Trackhawk. The prosecutor knows better, so when you get indicted, it won't just be grand theft auto. It will be stealing the car. It's going to be in possession of the car. It's going to be damage, felony damage to property because the window is bust and the steering column is cracked. You'll have all of these charges that are on there because they don't know what they're going to prove because they don't have the discovery. They just have the arrest. So that's why you will get arrested for 1 or 2 charges, and by the time you get indicted, it's 15. And that's how that happens.
So, okay, now next, I have 2 questions. I'm thinking of clips right now. This would be great for... Okay. First question is, what do you do? What is your advice for if you are under arrest? What should someone do? What are the first steps they should take? And
Charles, you can ask the question.
That's super relative because people want to know this all the time. And I know a lot of criminal lawyers, they do these clips online. Here's the first thing you do if you get ready. So y'all can do like a step-by-step. That'd be wonderful. Just for people to know, what do I do? Like if I get caught into something, if I was either innocent or guilty, how do I handle that?
So I guess the question, what advice would you give to someone that is being arrested or getting arrested, or the police come to your house looking for person A to arrest them?
First thing I would do is ask for a lawyer. I would not have a conversation with the police without a lawyer present. A lot of people don't understand that a lot of what you say will be used against you, even though they say that. They take it as a TV clip and don't take it serious enough. If the police come to your house to arrest you, they have enough to arrest you. There's nothing you're going to say that's going to change their mind at that point. The only thing you can do is confirm what they believe they know. Even if they're wrong, let your lawyer sort that out with you. If you're pulled over for a DUI, don't do any of the field sobriety tests. Again, if they're going to arrest you, they either have enough or they don't. And people will retain our firm to go with them to the police department. Okay, let's see what the charges are, and I'm going to talk to you about it. But do not say anything. People will a lot of times apologize for things. Apologies are oftentimes used as admissions and confessions. I'm so sorry I hit you. I'm sorry, baby, I didn't mean to hit you. Okay, you're apologizing and admitting it at the same time. Don't say anything. Talk to an attorney. Do not go into a police department thinking that you know better, I have nothing to hide, and talk to them without an attorney. I'm not saying that you don't talk to them. I'm saying talk to an attorney first. Have an attorney go with you. So if you're arrested, there's nothing that you need to say except I need an attorney present.
So then I guess another follow-up question. If I'm arrested and I'm now in jail, what are your thoughts of me talking to my attorney from the jail phone?
Well, it depends. For me, and this is different for each attorney, not all jails require you to talk to your attorney through a phone. So if you can talk to them face-to-face, that's better. I don't trust jail phones, even though attorney phones in the jail are not supposed to be monitored. I don't trust that. So if I'm talking to you in jail and I'm going to a visit, I'm going to ask you about things that I don't mind being recorded. When I need to talk to you about discovery, I'm asking for an individual room, so it's you and I talking individually, face to face, outside of the phone recording. There are some visits you're going to have to do through the jail phone and monitoring system as best you can. But to the point that you are talking about the details of the case or the defense of the case, try to avoid using a phone even with your attorney. But some jails don't give you that option. You have to use the jail phone. They say it's not recorded. And when it comes time to defend against your case, there's no trial by ambush. Ha! I have this secret evidence. I'm not going to, first of all, I'm never going to ask you, did you do it? There's never going to be those type of questions. When I'm asking you questions, assuming that this is being recorded, I'm asking you very factual questions that in the back of my mind, this may or may not be recorded regardless of what they say, but it's never going to be anything that prompts you to make an admission. A lot of times clients will hire us after they've already made an admission. So we're doing damage control by the time I get there anyway. But a skilled attorney is going to ask you very strategic questions on a jail phone.
And talking to the family on the jail phone is a no-no?
No, you should talk to them, but you talk to them about how's the baby, how's the weather, what's for dinner. Don't talk to them about the facts of your case. Definitely don't have them reach out to the victim or the alleged victim and ask them this, or have them try to run interference or talk to her, man, she this and that, or he, this and that. Don't send your family members on a goose hunt to talk to the named victim in the case. But if anything, you're talking to your family members, talk to them about hiring you an attorney or about getting in touch with a public defender if you're going that route. But always know that those calls, especially with your family members, are being recorded. So don't try to explain to them what happened. Don't explain to them how you're innocent and what the other person did. One of the biggest things that I will say when I'm talking to clients about their criminal case, people will tell me a lot of what's irrelevant. This is true in family law and criminal. People want to tell me, and I listen to what you're saying, but you want to tell me what you want to tell me. But I know what I need to know to defend against this case. If I'm looking at a ag assault, and in this ag assault, this guy is accused of shooting this guy, you're talking to me about him cheating with your girlfriend 3 years ago. I understand that upset you. It was 3 years ago. It's not going to be relevant now. If you have a continued history with this person, unless we're talking about self-defense, and it's been an antagonizing relationship back and forth, and he was the aggressor, and we're talking about how he's aggressor. If it doesn't tie back to this incident, the four corners of this indictment, telling me about things that are unrelated, telling me that I can't go to jail because I have a 3-year-old, that's not a defense. Let's not chase red hair. I can't go to jail. I can't do this kind of time. Man, I got to take care of my grandma. All of the things that you have to do instead of going to jail are not defenses. They lay flat. The prosecutor nor the judge cares about your responsibilities outside of going to jail. They're going to say your client didn't know he had a 3-year-old. Because if you're not talking to me about a defense, what are we talking about? Telling me that you continuing to tell me your obligations at home and why you can't go to jail is not a defense. I understand your obligations. I hear you. But when we're together, let's talk about the defenses to the case. Let's talk about the evidence. Telling me your wife is pregnant is not a defense. Telling me that you need to take care of your son because his father is dead and you're a single mom, it's not a defense. So I don't miss the human part of what my clients are saying, but I can't go down that road with you. I have to focus on defending you. I have to focus on the evidence. We're only going to talk about what your obligations are at home for so long. We have to really focus on how to defend your case to make sure you remain free, if possible, to continue with those obligations. But what you have to do at home is not a defense to what they're charging you with.
And then last bit, why should anyone choose y'all's law firm for their case?
I hate when people ask those such cheesy questions. It's so cheesy. When What I will say is this: when you're deciding on a law firm, I'm not going to tell everybody that they should choose my law firm. I'm not, because I'm not for everybody, and I definitely don't want to work with everybody. But I think when you're deciding who's going to represent you in something as crucial as your freedom, it should be somebody that you have a good rapport with, somebody that you trust to defend your freedom, your life, because it really, at the end of the day.
How do you decide that on a short period of time? Like
But let me finish my thought, though. At the end of the day, the decision that you make for the person that's going to defend your family, it goes so much bigger than just you. If you're in jail or not, it's going to affect your family in a real meaningful way. So when clients are saying, okay, I got a 3-year-old at home, if you go to prison for 10 years, obviously it affects that 3-year-old, your whole family. So the decision is far bigger than just you, even though you're the only one being charged. It's the whole family that this is going to affect. So you have to trust someone that you believe is going to best represent you, that's going to fight for you. And I think it matters when you're making that choice is to do your due diligence on that attorney. Do not choose, in my opinion, if you know you're going to trial, like the client that we were talking about that lost his job. He came through the door, I'm going to trial. I'm going to trial. I didn't do this. I was falsely accused. I'm going to trial. If you know that going in, do not choose an attorney that hasn't been to trial in the last year or two. You have a lot of trial attorneys that your whole focus is plea, whether it's a great plea or not. They don't pick jury trials. You're not going to trial. That's true in family law. There's a lot of family law firms out there that are going to represent you until a final hearing, and then they hand you off to another attorney. Are you going to be the one that go all the way to the end? Some are really good at mediation and negotiation, and then I'm going to pass it to Charles to go to trial. The same is true in criminal. Some attorneys are not trial attorneys. You're a criminal defense attorney. It doesn't make you a trial attorney. If you know in your head going in, I'm not going to trial. Most of my clients come through, I ain't going to trial. We got to figure out the best shit we can because I'm not going to trial. I can't go to trial. Okay. Understand what you want the outcome to be, and then you choose. Let that be part of your decision-making process. Do everything you can to research the attorney you're going to choose. If you Google an attorney, criminal attorney near me, look them up on social media. Get a sense of how long they've been doing what they're doing. If I was charged with something like a felony, a serious-ass felony, like ag assault, if you haven't been practicing at least 10 years, we have nothing to talk about. You will not be learning what you're doing with my freedom.
What questions do I need to be? But what questions or things do I need to be looking out for to know that they're a trial attorney and not one that's let's strike a deal? How do I know how to separate those attorneys?
In 2026, everybody's all over social media. Look on social media, see who they are, see the reviews, check the person's reviews, talk to other people and ask them, hey, do you know a good trial attorney? You know, like ask somebody else who's a happy client. You know anybody? Everybody knows somebody that knows somebody. Do you know a good defense attorney? Oh, my sister got an attorney she used, or my next door neighbor have a da-da-da-da. But look on social media. Ask the attorney. If you choose them however you choose them, ask them the questions. Ask them the questions. How many trials you went to last year? How many times have you ever picked a jury trial? Was the last jury trial that you went to? I love when people ask me, what's your success rate? Because an honest attorney who know what they're talking about is, my answer is always the same. Define success. That matters. Like, if I come in and tell you I've never lost a trial, walk away. Walk away. I've never lost a trial. If that means you're only going to trial on shit you know you're going to win. I love to win, and I'm a very sore loser. But if I'm not willing to try cases that I know are towing the line, then I'm not doing my job. I don't have to believe everything that you say. I have clients who absolutely, without a doubt, we throwing a Hail Mary. Their case does not look good, but they don't have shit to lose at all. At all. And they're willing to take it. And I'm like, nah, I'm not going to take that. My reputation too important. I need to be able to say I've never lost a trial. No. Let's put them in the box. Let's go. There are cases that you need to listen to me when I'm telling you, your attorney, and let me do my job. When I tell you this is not a good case, we don't have a strong defense. Don't let your emotions and your pride put you in the box. That's what I call going to trial. Don't let them put you in the box. In the witness box, put 12 jurors in the box and go to trial because you're on your pride and I can't. Because the worst thing about going to prison for 5 years is going to prison for 6 years, 5 years and 1 day, whatever. No one wants to go to prison, but you have to be honest with yourself and have a certain level of accountability. And if you want to go to trial, we're going to go to trial. But I think you have to have conversations with your attorneys about their experience going to trial. You have to have experience. You have to have conversations with your attorney. If you choose an attorney and you're working with them for 3 or 4 months and you're asking them questions and they can't answer your questions straight up, then you need to change attorneys. I'm not going to hire you and we're not going to trial for 3 years, and 2.5 years in, I'm still complaining to everybody else about you, and I'm not happy, and I'm going to trial. And then when you're found guilty, then you want to complain, you were trash. I was the best thing smoking for 3 years, and then when the jury came back with the wrong verdict, according to you, now I'm trash. You trusted that person for 3 years. If you don't trust them and you don't trust them to defend your life, they should not be your attorney. They just shouldn't. And so you have to have somebody that you feel comfortable sitting next to you, somebody that you've built that trust, you've built that rapport. While y'all are talking and talking through the discovery, listen to what they're saying. Be present. If I'm talking to you about your defense and this is our argument and this is the strategy, understand what I'm telling you. If I tell you this is not a good case and you insist on going, you choose the behavior, then you choose the consequence. If the behavior is I'm going to trial no matter what, cool. Understand that there are 2 options, that the way that this shit can go, left and right. And if we go in that way, let's go. Listen, I ain't never scared, but I need you to understand when we go into this, it's your decision. Because when the jury comes back with a verdict,
you're the only one that has to do the time.
You are going alone through that door. So it has to be your decision. I'm never going to tell you what to do. What I'm going to tell you is these are your strengths. These are your weaknesses. And if you want to fight, let's strap them up and go. Let's strap and go. We're going to put on a hell of a fight. Let's go. But you have to choose an attorney that you wholeheartedly depend on to fight for you. And again, if you working out a plea, work out a plea. It matters the venue. In some cases, rural Georgia, and we're going to trial in rural Georgia. Woo! Understand, it's called home cooking. It's a thing. It's a thing. You have judges that know all of this person, and everybody know these people. And you look around and don't nobody look like you, and everybody have their mind made up before you get in there. You might do better with a local attorney that's from Podunk, Georgia, and know all of these people and have a connection with these people. You may not need an attorney that comes in from Atlanta. Again, I'm not for everybody and everybody not for me. My team, because again, I'm not a solo. I have 7 attorneys on my team, and you need to understand you need to be matched with the attorney that you believe in that's going to fight for you. That's what you need to know when you're choosing your attorney on a criminal case. So again, there's a lot of moving pieces to hire an attorney for a criminal case. There's a lot of levels to, okay, I just got out on bond. Now what? You know, one of my best pieces of advice that I tell our criminal clients, commit one crime at a time. I cannot say that enough. For those of you, and I understand the looks on your face. Listen,
no, I understand.
I have no judgment because I've been telling you.
Look, speed and just speed. Don't speed and drink. I don't drink a lot.
If you have a body in the trunk, why are you doing 120 on the freeway with a body in the trunk?
You're just trying to hurry up and get him out of the trunk.
That's dumb. Let's not be dumb. Let's not be dumb and criminals at the same time, okay?
You don't like those prizes?
If you listen, you play dumbass games.
You get dumbass prizes.
If you have weed in the car, why are we speeding? Why are we speeding? Why are we running red lights?
Speeding, smoking, and
get your weed and go home. Smoke at home. Smoke at home. I never understand why people who smoke weed get caught up with the stupidest shit because you smoke weed and then you running back and forth with buying a 20 bag or $25 here and there. If you're going to smoke weed, listen, anything over an ounce is a felony. So go buy as close to an ounce, buy 3/4 of an ounce.
We're not condoning that.
I'm not condoning anything, but if you're going to smoke weed, go buy 3/4 of an ounce so you minimize the times in Georgia. You're going to minimize the time of risk that you're taking going back and forth to the weed man every week. Just buy 3/4 of an ounce and smoke it at home if you choose to break the law and smoke weed because it's still illegal in Georgia. But why are we going back and forth? Like, let's be smart about the choices we make.
Smoke at home, not in the car.
Okay, same thing with drinking. If I'm going to go have girls' night out and I'm meeting my girls to drink, okay, let's make a decision. Let's catch an Uber. Baby, I'm going to go drink with my girls, blah, blah, blah.
I'll come get you.
Can you come pick me up? Let's just let's take 2 minutes to think about how we're doing what we're doing. If we get in an argument, blah, 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 walk away. walk away. At the time that you want to bop her upside the head, at the time that you want to slap the piss out of them, walk away. Some of this stuff is so preventable because I promise you, it takes seconds to end up on the wrong side of the law. And there's no going back. There's no picking up the spilled milk. You can't pick up spilled milk. So make the decisions ahead of time. Don't have kilos in the trunk. Going 90 in the school zone. I cannot make this stuff up. I have clients that you literally got pulled. I have a client, past tense, who got arrested. Had a lot of drugs in the car. He going down the highway. His girlfriend is performing sexual acts on him while he going down the highway. So he get excited, caught up in the moment, and he is super speeding down the highway with a trunk full of drugs. And she's so in the moment, ooh, baby, baby, baby. She wants to perform special acts for him. And now we have a situation.
He could have just pulled over.
I'm just like, what?
I'm just saying.
You didn't know that was in the trunk? Come on, people. Come on, people. When I say break one law, if you're gonna be dumb, don't be real dumb. If you're gonna be dumb, just.
But we were able to get a favorable outcome.
We were, but I'm just saying that was insane. Some of this stuff, I'd be like, is it a hidden camera? Like, you are kidding me. Okay.
So
ounce of
the
prevention.
moral of the story is break one law at a time or none at all.
None at all. I say none at all.
In the event that,
just as sure as water wet.
You need to find an attorney. Certainly you can give us a call and see if we can be a match and be a good fit. But
I have an
stay safe.
Excellent team of criminal defense attorneys, and we are never scared to go to trial.
This is true.
Senior trial attorneys in criminal law.
I've been to all the trials of this one.
I'm just saying. There's a lot of layers to a criminal case. Just make sure you start out by having a great team on your side that has the experience to give you the outcome that you need.
Like, love, share, subscribe. Any questions that you may have, feel free to shout them out. We try to make sure we stay on top of the comments. And certainly, if you need our help, you can give the office a call, 404-330-8833.
TDE, Vows and Verdicts, Episode 2.
Till next time.